Courts open door to Trump's terrifying occupying force fantasy. I must say, Donald Trump commented, "I wish we had an occupying force." It was June 1st, 2020. The president, then in his first term in office, was having a phone call with the nation's governors to discuss the ongoing Black Lives Matter protests taking place nationwide in response to the murder of George Floyd at the hands of a Minneapolis policeman. He was urging the governors to call in the National Guard in response to BLM protests in their states. Otherwise, he threatened he would do so himself. "You have to dominate, he told them, while labeling the protesters terrorists. Otherwise, he claimed, they are going to run you over." Later that morning, Trump left the White House and took his infamous walk through Lafayette Park, where members of the Washington National Guard, the FBI, and the Drug Enforcement Administration, and several other agencies joined by guard units from a number of states confronted protesters. As I recounted in my book, Subtle Tools, protesters threw eggs, candy bars, and water bottles, while law enforcement shot rubber bullets, launched pepper balls, and fired tear gas into the crowd. Several weeks later, protests in Portland, Oregon, tested the president's resolve to send an occupying force. Although he didn't then go as far as to send in the National Guard, as he had threatened in that phone meeting, he did deploy federal agents to counter the protesters without consulting the governor of the state. 775 Department of Homeland Security agents from U.S. Immigration and Customs Enforcement, U.S. Customs and Border Protection, and elsewhere appeared on the streets of Portland, authorized by the presidential edict to protect federal buildings. As if to intentionally blur the borderline between military and civilian authorities, the federal agents arrived dressed in black military-looking uniforms without identifying insignia and drove unmarked vehicles. The administration justified the deployment by arguing that local law enforcement was unable to effectively control the protests. Not surprisingly, Oregon Governor Kate Brown and Portland Mayor Ted Wheeler protested, claiming that local law enforcement was perfectly capable of handling the protests without federal aid, and that the presence of federal agents with their aggressive tactics, including the use of tear gas and rubber bullets, had only provoked the protesters, making the situation much worse. My understanding is that a lot of the times when police show up to these things, their whole directive is to use force as a means of reducing force, which oftentimes, unsurprisingly, doesn't work. And so, yeah, it shouldn't be surprising that a lot of the times when the cops come in, rubber bullet guns blazing, firing tear gas and stuff, that it's only going to make things worse. That doesn't seem inconceivable. That seems somewhat reasonable to me. Now, does that mean that the police should never come in and do something? Absolutely not. Of course, there are plenty, of justifiable circumstances in protests where the police should and very much should come in. But to say that they have no effect or that they don't have a provoking effect on the protesters, that's never the case, is ridiculous. Of course they do. Sound familiar? Fast forward to today in Los Angeles. Donald Trump is once again president, and immigration raids across the country are hurrying to meet the White House target of 3,000 arrests per day. This time around, Los Angeles has become the focal point of the resulting battle over federal versus state authority. In early June, responding to an outbreak of protests challenging the administration's brutal immigration raids, Trump sent 700 active duty Marines and 4,100 National Guard into that city to counter the protesters. Los Angeles Mayor Karen Bass, California Governor Gavin Newsom, and California Attorney General Bonta, they don't like her enough to put, they put Los Angeles Mayor Karen Bass, they gave her first and last name, California Governor Gavin Newsom, they gave his first and last name, and California Attorney General Bonta, they didn't think she was deserving of a first name, have protested resoundingly, claiming, like their Portland counterparts, that the deployment was unnecessary and counterproductive. Mayor Bass has maintained that the local authorities had the situation under control, concluding that there was no need for the National Guard. Summing up the consequences of the deployment, Governor Newsom considered them to be intentionally causing chaos, terrorizing communities, and endangering the principles of our great democracy. It is an unmistakable step towards authoritarianism. Attorney General Bonta echoed Newsom by insisting that the troops were instigating violence, not diffusing it, and suing the Trump administration for illegally taking over a state National Guard. Where all of this may be headed is anyone's guess, but Portland's attempts in 2020 to fight back against the deployment of federal agents, despite the wishes of local authorities, provide some guidance about what to expect, as well as lessons learned when it comes to the role of the courts, of dissent by local and state leaders, and of the path down which American law may be headed in relation to the president's ability to usurp the power of local authorities. This seems like a weird point to make because, it's not so much about usurping their power, right? The federal government always has authority over state and local interests. That's the supremacy clause, right? The federal government is the daddy, is the king of the land. They have the final say. I think more specifically, and maybe it's the problem with their verbiage, but I think more specifically what they're referring to is the power of the executive. The executive branch of the government only has certain things that they are and aren't allowed to do, while the federal government and the president are the supreme, commanders or whatever. They aren't like kings. They don't have unlimited, unchecked power. So this verbiage is just a little bit weird. The battle over federal versus state authority is rooted in laws pertaining to presidential powers. The Posse Comitatus Act, as former United States Attorney General Joyce Vance explains, prohibits the federal government from using the military inside of the domestic United States for law enforcement, absent truly compelling circumstances. But there are exceptions. Title 10 of the U.S. Code fleshes them out, authorizing the president to federalize the National Guard and deploy it to a state in rare instances of invasion, rebellion, or the need to execute federal laws. In Portland in 2020, President Trump labeled the protesters terrorists and threatened to bring in the National Guard if the protests didn't stop. Yet days later, he pulled back from that threat, telling George Stephanopoulos on ABC News that such a move would have violated the law. "We have to go by the laws," he said then. "We can't move in the National Guard. I can call insurrection, but there's no reason to ever do that, even in a Portland case." He further concluded that we can't call in the National Guard unless we're requested by a governor. So it seems like he used to be against that. Interesting. How things have changed. On June 7th, Trump issued a memorandum declaring his authority to deploy both the National Guard and the armed services. In light of these incidents and credible threats of continued violence, the memo authorized the Secretary of Defense to coordinate with governors to deploy both the National Guard and any other members of the regular armed forces as necessary to augment and support the protection of federal functions and property in any number determined appropriate in his discretion. In other words, Secretary of Defense Pete WikiLeaks Hegseth has given unprecedented authority to direct events on the home front, challenging the Posse Comitatus Act's prohibitions. Since then, 4,100 National Guardsmen and 700 Marines have arrived in Los Angeles. Their presence has been notably aggressive. Meanwhile, Department of Homeland Security agents have swarmed the streets, local employment places, and immigration offices not wearing identifying insignia. As Nick Terse reported at The Intercept, since June 8th, there have been 561 arrests related to protests across Los Angeles. 203 for failure to disperse were made on the night of June 10th after Trump ordered in the National Guard and Marines. Meanwhile, Trump used the growing conflict to threaten Governor Newsom with arrest. One thing that keeps coming to mind for me with all of this is how Nixon or Reagan, whichever one of them started the whole Reefer Madness. I'm pretty sure it was Reagan. Started the whole Reefer Madness stuff. It came out much later that his whole explicit goal, the reasoning behind going so hard against marijuana and wanting to make it illegal, is basically to target his political rivals. He knew that a huge portion of Democrats, of liberals, of people, not voting for the Republicans at the time, smoked weed, and that a huge part of the hippie movement at the time, which was huge, was very, very heavily leaning towards the liberals, and that it would be very hard to beat them with that understanding. So they went after weed explicitly for the purpose of trying to arrest and get felonies on as many of those ostensibly mostly hippie smoking pot, so that they can basically help them electorally, right? If they could take 10,000 of them out of the voting pool because they got felonies, and 9,500 of those 10,000 would have voted liberal, well, that's pretty good for them. That's, they just effectively, changed the difference in the votes by 9,500. That's significant. And so I can't help but keep coming back to that like they do directly benefit, even on a very, very small scale, of arresting as many protesters as possible and slapping them with felonies and upping the charges as much as possible to the point that they're felonies so that they can not vote anymore. I just can't help but think that that is a goal of theirs somewhere in the mix, right? I have no reason to think that if Reagan was wanting to do that, that suddenly the Trump administration of all administrations is altruistic and good meaning and good intentioned and doesn't want to do that. Nobody believes that. Come on. Meanwhile, Trump used the growing conflict to threaten Governor Newsom with arrest. That's insanity, bro. Justifying his deployments. Just imagine for half a second, Kamala Harris was elected and she threatens to arrest Ron DeSantis. Just imagine for half a second. Okay, the conservatives would lose their minds. They'd be calling for impeachment. It would be World War III. It would be World War III. Okay, but they're not principled. They don't care. Justifying his deployments, the president labeled the protesters insurrectionists, laying the groundwork for invoking the Insurrection Act, which, as Joyce Vance explains, allows the military to be used for domestic law enforcement, but, and it's an important caveat, only to restore order. Yeah, but like all of these terms like restoring order and what is a national threat and what isn't and whatnot, all of these are extremely vague terms that it seems like the Supreme Court is more and more deferring to the executive to interpret, which is problematic. For help in pushing back against the deployments, California officials, like their Portland predecessors, have turned to the courts. This time around, however, the Trump administration has revised its reading of what is lawful, and so far, the judiciary seems to be bending the president's way. Exactly like I said, yeah. A lot of the readings, a lot of the provisions in this law, a lot of the verbiage is vague, and that ultimately that vagueness comes down to the court. And then a lot of the times recently, the court has just been kicking it back to the executive saying, oh, it's up to you guys. Do whatever you want. But if it was like, I guarantee you, if it was the shoe is on the other foot, if it was a liberal trying to do something like liberal oriented or whatever, there's no way on earth they're kicking it back to them. They're making a very clean ruling or whatever. They're going to use their major questions doctrine or whatever made up nonsense. They don't even have to make up anything, right? They have a majority on the Supreme Court. They don't even have to write majority opinions or dissenting opinions. They don't even have to do any of that anymore. They could just make their rulings and say nothing. On June 9th, Governor Newsom filed a suit in federal court claiming that the deployment of the National Guard and the Marines violated the Constitution and exceeds the president's Title X authority. The suit argued that the deployments were unwarranted and the administration had failed to try to coordinate with the governor. California Attorney General Rob Bonta. So now Bonta gets robbed. Now they treat Bonta correctly. They give him his first name. I guess he does have a first name. He's not just named Bonta. California Attorney General Rob Bonta elaborated on the limitations of the law. Let me be clear, there is no invasion, there is no rebellion. The president is trying to manufacture chaos and crisis on the ground for his own political ends. Federalizing the California National Guard is an abuse of the president's authority under the law, and not one we take lightly. We're asking a court to put a stop to the unlawful, unprecedented order. In 2020, the Oregon Attorney General had filed suit in federal court in response to the actions of the federal agents. As the New York Times reported, the lawsuit said federal agents were violating the First, Fourth, and Fifth Amendments to the Constitution by denying the right to peacefully protest, failing to provide due process, and conducting unreasonable searches and seizures. Ultimately, the federal judge dismissed the case, claiming that Attorney General's office did not have standing to bring the case because it had not shown that the issue was an interest that is specific to the state itself. The Oregon court also shied away from tackling the larger question of what powers the federal government actually had in such situations. Suits brought by private parties as well as the American Civil Liberties Union on behalf of individuals who were injured, harassed, or abducted by federal agents were more successful. Initially, a judge expanded a temporary restraining order from local law enforcement to federal agents, blocking the use of tear gas and projectiles against journalists. As the suit progressed, more weapons in the federal agents' arsenal, including rubber bullets, were prohibited. When the president asked for the TRO to be removed, the judge not only refused, but levied a requirement that government agents wear identifying insignia, an effort to introduce a measure of accountability into the conflict on the ground. It seems like inconceivable to me that they would not have the ICE agents or just any federal agents like clearly labeled what they are. To me, that builds the case for this chaos argument that he is using the National Guard. He is using these federal agents as a way to instigate chaos, as a means to justify sending in more and exerting more authoritarian executive control over these localities. Because if you are acting in good faith, if you really truly are acting in good faith and just want to use these federal agents to quell things, to go after immigration or do whatever it is that you're trying to do, that you're pretending to do, you would have them clearly labeled. You wouldn't want all of the problems that come along with them not being clearly labeled, right? To me, that shows that them not being clearly labeled is a deliberate choice. And why would you make that choice? It's to sow chaos. On appeal, the Ninth Circuit Court of Appeals raised the larger issue of federal versus local authority, resoundingly rejecting the legality of the presence of federal agents in Portland while agreeing with the lower court's findings of a disturbing pattern of unwarranted force by federal agents. That court not only reinstated the TRO against federal agents attacking journalists, but underscored the fact that federal agents had gone beyond protecting federal buildings to actively confronting protesters while widening the perimeter in which they could act outside those buildings and so wrongfully overstepping the authorities expressly reserved for local law enforcement. And at that time, there were also help from within Trump's circle. In a settlement arranged between Oregon Governor Kate Brown and Vice President Mike Pence's staff, federal law enforcement officers were indeed replaced with members of the Oregon State Police. As Nick Blosser, Brown's chief of staff and one of the negotiators, pointed out recently, referring to Vice President Pence, there was at least someone in the administration that knew that this violence needed to come to an end. I'm not sure who is there to negotiate with now. I would just love to ask, like all of the normie Trump supporters, why do you think Pence is not running with him anymore? Why do you think Trump did not choose Pence to be his vice president again? Okay, I would love to hear the wide range of weird answers that they give, because I guarantee you none of them are connected to reality. Today, in Los Angeles, the courts are similarly engaged in a suit over the administration's deployment of federal agents to counter protesters. So far, however, the outcome is trending very differently. Earlier in the month, a federal judge issued a TRO against the National Guard in that city. In a 46-page ruling, Judge Charles Breyer, the brother of retired Supreme Court Justice Stephen Breyer, rejected the government's characterization of the protests as a rebellion and excoriated the president for assuming powers beyond his constitutional and statutory authority. That's the difference between a constitutional government and King George, was the way he put it. In addition, Judge Breyer returned the authority to deploy the National Guard to California rather than the federal government. The administration immediately appealed, as in the Portland case. The appellate court is once again the Ninth Circuit. On June 18th, there was a hearing before a panel of 3 judges, 2 of them Trump appointees and 1 a Biden appointee. Repeatedly, the judges seemed to reject the notion that the law requires the active involvement of the governor in the decision to deploy such troops, appearing to side with the federal government lawyer who told the judge again and again, our position is this is not subject to judicial review. In other words, the president should have free rein to do as he pleases. Basically, yes, they're arguing that the court does not have any standing over this and that it is up to the executive to interpret these laws as they see fit. Now, typically, this is where the court would come in and say, no. But because this is an extremely ideological court, they only do that when it's convenient and when they want to, especially the Ninth Circuit. The Ninth Circuit of Appeals is notoriously like ultra conservative and ultra insane and ultra ideological. In their ruling, the appellate judges agreed with Trump and not with the state of California, overruling the district court judge and unanimously agreeing that the president had acted lawfully and that his failure to notify the governor before deploying those troops was not grounds for obstructing the president's order. In other words, he could indeed keep control of the troops in LA. In short, the case has taken us another step down the road of the maximalist view of executive power. The ruling suggests that that last year's Supreme Court immunity decision, allowing a president to do more or less whatever he wants while in office without fear of retribution, was indeed a game changer. As a reminder, in July 2024, while Trump was running for office a third time, the court ruled that under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from crimes, from criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least preemptive immunity from prosecution for all of his official acts. The court then added, there is no immunity for unofficial acts. That's the thing, though. How do you define the difference between unofficial and official acts? And I really, really, really do not trust the Supreme Court makeup that they will fairly and objectively and unbiasedly interpret what is an official and official, what is and isn't an official or official act. I guarantee you, I'm making a prediction right now. I guarantee you, the next time a Democrat is in office, they are going to make a series of rulings that are completely antithetical to the rulings they made under the Trump administration, that are exactly the opposite with regards to the amount of power they're giving to the executive. But nothing's going to matter, because there's absolutely, what are you going to do about that, right? There's nothing we can do about them being hypocrites or about them being cynical and ideological in that way or biased. There's literally nothing we can do. We just have to suck it up and deal with it. In the context of recent events in Los Angeles, rather than immunity for criminal activity, it suggests that the Supreme Court might indeed support immunity from legal pushback for acts it committed at the state level. And that would, of course, remove yet another of the checks and balances that once underlay the protections against untethered presidential power in the American system of government. How this will play out at the Supreme Court the next time around is anyone's guess, and may turn on the issue of whether that court assesses that there really was a rebellion in Los Angeles, the government's premise for bringing in federal troops. Nonetheless, this should certainly be considered a frightening moment. After all, that presidential memorandum authorizing the federal deployment to LA was in no way limited to California. In fact, there was no geographical specificity to it at all, and no specific type of protest named in the memo. It was a blanket authorization for deploying federal troops based on unspecified acts of violence, disorder, and protests. If California is a sign of the future, it seems ever clearer that the courts have little appetite for standing in the way of this president. In addition, as loyalty to him is the first requisite of government officials, any pushback from within the ranks of his administration seems essentially inconceivable. Yeah, because we've undergone a reverse Darwinian process to select for the most unqualified, insane people to be in this administration. Bro, if you look at the cabinet of people he had in his first term from 2016 to 2020 versus the cabinet of people he has now, bro, it was like the NBA All-Star team versus JV middle school team, right? Like, we have the worst of the worst in office now. We have the maximalists of the opportunists, of the cynical corporate interests, of the disgusting religious ideologues and theocrats. It's tempting to point to the moments in recent times when we should have seen this coming. The growing powers granted to the president in the name of the global war on terror, the unchecked ability of the president to repeatedly make acting appointments and fire those in his cabinet who oppose his will, the co-opting of members of Congress through threats of primarying them out of office or grants of vast amounts of money should they demonstrate sufficient loyalty to the president. But as it stands, this is probably not the time to focus on who's to blame in the past. Instead, it's time to consider the future and our power to strengthen the fundamentals of our democracy before it all is lost. Only if our trust in the law and the courts is restored will we truly be able to turn our thoughts to the mistakes and missed opportunities of what by then would be a painful past. The problem is restored if only our trust in the law and the courts is restored. But how could you possibly have the trust of the law and the Supreme Court restored if they're as ideological as they are, if they are as biased and clearly acting politically as they are? How could anybody possibly hope to? It's not a matter of trust, right? It's not like